California Dreaming Podcast discusses a variety of topics with details that may contain acts of violence, explicit language, and mature content not suitable for children. Listener discretion is advised.
Okay, dreamers. This is the second part of a series on the wrongful conviction of death row inmate Kevin Cooper. If you haven't listened to part 1, pause this, go back and listen to episode 106 first, then come back and listen to this. In part 1, we went over the details of the 1984 murders of Doug and Peggy Ryan, their 10-year-old daughter Jessica, and their neighbor 11-year-old Christopher Hughes. We discussed the initial investigation and how information led detectives to come to believe an escaped convict named Kevin Cooper was the perpetrator of this crime. Kevin had escaped from a prison not too far away from where the Ryans' house was located, and he took refuge in a vacant home that was the closest neighboring residence to the Ryans. Undisputed evidence placed him in the home around the time the murders are believed to have taken place, and Kevin himself has not attempted to deny that. He was there, but he says he didn't do this crime. We reviewed some of the evidence investigators presented at trial that resulted in Kevin Cooper's conviction and subsequent sentence of death. But I am here to argue that Kevin Cooper, no matter what we may think of him, escaped convict, career criminal, possibly even having sexually assaulted a woman in the past, though he's never been charged or convicted of that. No matter how unsavory this man is, I believe wholeheartedly that he is innocent of these murders. I am going to start with a more than 100-page report published by one of the dissenting judges in the Ninth Circuit Court of Appeals that denied Kevin's petition for a new hearing on this case, Judge William Fletcher. And in his report, he got real about his feelings when it came to the entire case against Kevin. He started off by saying that the state of California may be about to execute an innocent man. How heavy does that statement weigh on you, dreamers? The state of California is about to execute an innocent man. We came within hours of doing exactly that, if not for a last-minute stay of execution back in 2004. He was that close. And I can't even begin to fathom how anyone would be able to rest easy if his execution had actually been carried out that day. Judge Fletcher discussed the shoes first. If you recall, 2 days before the murders, Kevin had walked away from the minimum security wing of the California Institute for Men in Chino, simply by walking across an apparently open and unguarded field. Now, just before Kevin's 2004 scheduled execution, the warden of the prison at the time, Midge Carroll, who has since retired, provided a sworn declaration in which she stated that she came to learn from her staff that the shoes issued to prisoners were not prison manufactured or specifically designed prison-issued shoes, but instead were common tennis shoes available through Sears and other such large retail chains. She also stated that she knew of this information during the time of the investigation and told investigators about it prior to trial. It had been a key point in the prosecution's case during the trial was that the shoe prints at the crime scene and in the Lee Slang house where Kevin had been hiding were identical, made by Pro-Ked, and that they were only distributed to prisons and jails. Midge Carroll's information was clearly exculpatory and was not provided to Kevin or his defense team prior to the start of trial. Next, I want to talk about that tan t-shirt that was found along the roadside leading away from the Ryan house that I mentioned in part 1. It was tan and it was stained with blood, and it was discovered shortly after the murders during the initial search of the area surrounding the Ryan home. Now, the initial testing of the stains on the t-shirt indicated that it was blood consistent with one of the victims, but none of the stains were consistent with Kevin's blood. This information was presented at his trial as part of his defense, though it did little to help his case, as an absence of Kevin's blood did not equate to innocence. So years later, once post-conviction DNA testing became a thing, Kevin insisted that this t-shirt be retested, which the state of California did perform. Kevin was certain that the DNA results would prove what he had been saying all along. His blood nor his DNA would be found on this t-shirt, that he was innocent of this crime. But much to his surprise, the blood on the t-shirt came back as a positive match for Kevin's DNA. The one and only explanation for this would be that Kevin's blood was planted on the t-shirt, and the only possible source would have had to have been the blood taken from Kevin by law enforcement as a part of the initial investigation. A vial of blood was indeed taken from him by the San Bernardino County Sheriff's Department on August 1st, 1983, 2 days after Kevin was taken into custody off that boat that he had been sailing around on. That blood would have contained a preservative known as EDTA. The appellate court stated that the presence of this preservative on those bloodstains would be proof that Kevin's blood was not on the t-shirt at the time of the killings. The district court was ordered to go back and test Kevin's blood on that t-shirt for the presence of EDTA. Also, in the same vein of testing and retesting, they addressed the issue of either blonde or light brown hair found clutched in 10-year-old Jessica Ryan's hand. The district court again was ordered to subject those hairs to mitochondrial DNA testing. Despite the orders of these two tests to be conducted, the district court held their hearings for Kevin's application for habeas corpus in 2004 and 2005. Both of them were denied. Judge Fletcher said in his report, "The district court failed to provide Kevin Cooper a fair hearing and directly disobeyed the appellate court's orders to perform these two tests on the blood and on the hairs. The district court impeded and obstructed Kevin's attorneys at every turn as they sought to develop the record. The court imposed unreasonable conditions on the testing that the court directed. They refused discovery evidence that could have been available as a matter of course. They limited testimony that should not have been limited. And they found facts unreasonably based on a truncated and distorted record." And Judge Fletcher went on, "The most egregious, but by no means the only, example is the testing of Kevin's blood on the t-shirt for the presence of EDTA. The district court so interfered with the design of the testing protocol that one of Kevin's scientific experts refused to participate in testing. The district court allowed the state-designated representatives help choose the samples to be tested from the t-shirt. Then the court refused to allow Kevin's scientific experts to participate in the choosing of the samples. The district court also refused to allow Kevin's experts to even see the t-shirt, just as Kevin had been saying all along. A careful analysis of the evidence before the district court strongly suggests that the results obtained by the state-designated lab was valid. However, the court allowed the state-designated lab to withdraw the test results on the grounds of contamination in the lab. But then, the court refused to allow any inquiry into the alleged contamination. The court refused to allow Kevin's experts to review the bench notes of the state-designated lab. Then the court refused to allow any further testing of the t-shirt, even though such testing was still feasible. Now, dreamers, we will revisit this t-shirt later on in this discussion, and there are a couple of other pieces of circumstantial evidence involving a beer can or a bottle found in the area between the Ryan home and the Lee Slang home, and some burrs found on Jessica Ryan's pajamas. I haven't overlooked that evidence. However, we will also discuss that a little bit later on when we break down the validity of the evidence against Kevin Cooper in this case. So next, Judge Fletcher addressed the state's theory at trial that Kevin Cooper acted alone in killing Doug, Peggy, Jessica, and Christopher, and nearly killing Josh, and that the motive behind the killings was to help further his escape from prison. As we had mentioned earlier, and the judge mentioned in his report, Kevin made several phone calls from the Lee Slang house looking for money or other assistance from two female friends of his, both of whom refused money or help. However, money was in plain view on the kitchen counter and was left untouched. Credit cards and money in Peggy's purse, also untouched. So, what is Judge Fletcher inferring here? If Kevin Cooper committed these murders, and remember, he is a burglar by trade, then why did he not steal any of the money or credit cards from the Ryan home? Those are the exact things a burglar such as Kevin would seek out and take with him. And admittedly, later on, as he made his way to Mexico, and he paid for a hotel in Tijuana by way of a stolen purse. Yet he went into the Ryan home, killed 4 people, almost a fifth, and didn't take the purse or the money? Come on. The last phone call made by Kevin from the Lee Slang house ended at 8:30 p.m. on Saturday, June 4th, 1983, the same night as the murders. Kevin testified at trial that he waited until dark, and this is summertime and it gets dark after 8:30, that time of the year here in Southern California. Kevin finished up his last phone call. He departed from the home by foot after that call and hitchhiked to Mexico. It is confirmed that Kevin checked into a hotel in Tijuana at 4:30 p.m. the following day on Sunday, June 5th. According to witnesses, Kevin's hair was tightly braided when he checked in, same as it was when he escaped from jail. The Ryan station wagon had been parked in the driveway of their home with the keys in the ignition throughout the evening of June 4th. On June 11th, the vehicle was discovered in the parking lot of a Long Beach church where it had been sitting for several days, according to witnesses. The judge noted that Tijuana is 125 miles or 201 kilometers south of the Ryan house, while Long Beach is 45 miles or 72 kilometers west of the Ryan house. So what is Judge Fletcher inferring here? Well, to me, what he is pointing out is what sense does it make if Kevin Cooper is attempting to flee to Mexico for him to abandon that car that he supposedly took that many miles and or kilometers out of the way and not near the Mexican border. Because Long Beach is not on the way between Chino Hills and Tijuana. It is far west and north of the border. And there's more about the vehicle that we will get into later on too. The judge continued on his report stating that there is substantial evidence that 3 white men, not Kevin Cooper, were the killers. Some of the evidence had been presented at trial, while some of the evidence, and it was exculpatory, was deliberately destroyed by the San Bernardino County Sheriff's Department, thereby making it unavailable to be submitted as evidence in the trial. Some of the exculpatory evidence was kept hidden from Kevin and his defense attorneys, also making it unavailable for use as evidence at trial. Josh Ryan, the only survivor, first told San Bernardino County Sheriff's deputies that the killers were 3 white men, possibly Hispanic. This information was an entry into the police log on the afternoon of June 5th, 1983, after Josh had been spoken to in the hospital. And that was the source of the information sent out that the murder suspects were 3 young white males driving the Ryan station wagon. On the evening of the murders, a couple had driven to Chino Hills from Los Alamitos to drop off a horse trainer. The drive is about 37 miles or 60 kilometers southwest of Chino Hills, and there is a horse racing track located in Los Alamitos. As they were about to pull out of the horse trainer's driveway, they were made to wait for a car driving rapidly down Carbon Canyon Road from the direction of the Ryans' house. The husband who had been driving testified at trial that he stopped to wait for the car to pass and described it as a light-colored station wagon with a luggage rack. He had to be coaxed a little bit by Kevin's attorney, but he finally admitted in his testimony that he told the sheriff's investigators that the driver was a young white male. The wife, who was the passenger, said that the car was tan or cream-colored, and she thinks it had a luggage rack and that she saw 3, maybe 4 people in the vehicle. The Ryan station wagon was white with wood paneling and did have a luggage rack. So clearly, these witnesses saw the Ryans' vehicle being driven away by white men, 3, maybe 4 of them, and clearly, Kevin Cooper is not white. The medical examiner, in his observations of all the injuries suffered by the 4 murder victims, concluded that there were multiple weapons used during the course of the attack. Due to the number of victims, 5, including Josh, the survivor, and the sheer number and nature of the wounds inflicted upon everyone, the coroner initially reached the conclusion that there was more than one killer. Also noted, while Josh was in the hospital following the murders, on 2 occasions he saw Kevin Cooper's picture on TV, and both times he said that that was not one of the killers. So circling back to the t-shirt that we discussed earlier, it was discovered by a sheriff deputy on June 7th, a little more than 2 days after the killings. The t-shirt was a tan, medium-sized, Fruit of the Loom t-shirt with a front pocket. At the time, the blood on it was tested and it was found to be consistent with Doug Ryan's blood, but also inconsistent with Kevin Cooper's blood. Post-trial DNA testing that was conducted at Kevin Cooper's insistence once DNA technology was available revealed that the shirt contained DNA consistent with Doug Ryan and Peggy Ryan, but the testing also revealed that at least one bloodstain on the t-shirt contained Kevin's DNA too. Now remember, dreamers, initial testing back in 1983 revealed none of the blood was consistent with Kevin's blood type. Yet now, magically, there it was. Also, I want to point out that it would have been very easy to find out if this Fruit of the Loom t-shirt was an item that was standard issue in prisons. It would have had to have been, right? I have not read any information that confirms that this is something prisoners were given, or if it's not. Perhaps finding out this information would not have fit into the San Bernardino County Sheriff's Department's narrative that Kevin Cooper was the perpetrator of these murders. Now let's talk about a woman named Diana Roper. She had quite a few things to say about Kevin Cooper, and I'm just going to put this out there right now. This woman has been described as a white supremacist, and she would have absolutely no reason to want to do anything to help Kevin Cooper other than a deep desire to want the truth out there. If for no one else, Josh, the only survivor. And she has stated that she knows what happened and Josh and his family have not truly gotten justice. So both in 1983 and in 1998, Diana Roper provided a sworn statement describing an identical Fruit of the Loom t-shirt with a front pocket that she had purchased for her boyfriend at the time, a man named Lee Furrow. And in both of these statements, she said that Furrow was wearing that t-shirt the evening of the murders, June 4th, 1983. At the time the murders took place, Lee Furrow was residing with Diana Roper about 45 miles or 72 kilometers east of Chino Hills in Mentone, California. On that day of the murders, Furrow, Diana, her sister Carrie Kellison, and neighbors Michael and Rebecca Darnell attended a music festival at the Glen Helen Amphitheater, approximately 30 miles or 48 kilometers northeast of Chino Hills. That afternoon, Lee Furrow had picked up Michael Darnell from the county jail as he had been held there overnight. Darnell said that he and Furrow arrived at the music festival after dark. Debbie Glasgow, a woman who was having an affair with Lee Furrow, told police that he arrived at the music festival around 11 p.m. that evening. Rebecca Darnell told investigators that she left the music festival with her husband Michael, Diana Roper, her and her sister Carrie, but Lee Furrow did not leave with them. In her 1998 statement, Diana Roper said that on the afternoon of June 4th, 1983, she and Furrow were at home getting ready to go to the music festival. He was wearing a medium-sized Fruit of the Loom beige t-shirt that had a pocket on the front. She had purchased him the t-shirt at a Kmart before June 4th, and that she told the exact same story to the sheriffs 15 years earlier regarding the t-shirt. She reiterated in her statement both times that she was interviewed 15 years apart that the t-shirt that she was shown depicted in the evidence photographs looked exactly like the t-shirt Lee Furrow was wearing on June 4th, 1983. It was same in size, color, and the pocket. She said, quote, "I am absolutely positive the photograph of the t-shirt matches the t-shirt Lee was wearing at our house on the afternoon of June 4th, 1983. During the early morning hours of June 5th, 1983, Diana and her sister Carrie had returned to her home in Mentone. While they were in the living room, she received a phone call from Furrow sometime between 1:30 and 2 in the morning of June 5th, and he asked her if she would come pick him and Debbie up from the festival. Diana refused and hung up the phone. A few hours later, a car pulled into Diana's driveway. Carrie went over to the French doors to look outside, but Diana did not. A moment later, Furrow and Debbie came through the front door, and they were in a big hurry. She then heard the car leave. Furrow was wearing long-sleeve coveralls with a zipper in the front. The coveralls were splattered with blood, and there was horsehair on the lower leg area. Furrow no longer had on the tan t-shirt and the Levi's jeans that he had on earlier in the evening. Furrow made his way to the back of the house as it appeared he was in a hurry. He took the coveralls off and left them on the floor of the closet. After he changed his clothes, Furrow and Debbie immediately left on his motorcycle, having been in the house for no more than 5 minutes, as it was clear they were in a rush to leave. After Diana Roper heard about the Ryan Hughes murders in Chino Hills, she contacted the San Bernardino County Sheriff's Department. They came to her residence, and she told them what she knew, and she showed them the coveralls she found in her closet, how they were covered in blood, and she handed them over. One of the deputies laid them across the hood of their patrol car and examined them. And then they took them and they left. A couple of days later, Diana saw Lee Furrow visiting her neighbor's house, and she let him know that she turned the coveralls over to the sheriff's department, and he became very irate that she had done this. And we will come back to these coveralls in just a moment. Following that, Furrow took measures to alter his appearance by cutting off most of his hair, and he had kind of bushy long hair, possibly like a mullet, and he shaved off his sideburns and his mustache. Diana also heard a report on the news about a hatchet found near the scene of the murders. So when she learned of this piece of evidence, she walked over to the area of the house where their washer and dryer were situated, which was a place where Furrow kept all of his tools hanging from nails on the wall, and the hatchet that he once had hanging there was no longer there. And in looking at the picture of the hatchet found near the scene, Diana Roper believed it to be the one owned by Furrow that was now missing. She could not be 100% certain, but she believed that the curvature of the handle was identical to his, which had sort of a Native American decorative design pattern on it. In her interview, Diana Roper did admit that she had been under the influence of drugs on the night of June 4th. In a separate sworn affidavit dated November of 1998, Diana's sister Carrie confirmed many of the details Diana had provided, but she also added a critical detail. During the early morning hours of June 5th, 1983, she and Diana were in the living room talking when they heard a car pull into the driveway. She estimated the time to be sometime after 3 a.m., but before the sun came up that morning. She looked out the windows of the French door and saw Lee Furrow and Debbie Glasgow exit out of the car. It was too dark for her to be able to identify the other occupants who remained in the car. However, there was enough light to see that it was a station wagon, kind of light brown in color. Lee Furrow and Debbie came inside. Furrow was wearing long-sleeve coveralls which were splattered in blood. He walked to the back of the house and changed his clothes. When he emerged from the bedroom, he was no longer wearing the coveralls and apparently left them in the back of the house. Furrow and Debbie immediately left on his motorcycle. A week or so after the Ryan Hughes murders, Carrie was interviewed by police. She never told them the above information because she was terrified of Lee Furrow and Debbie Glasgow. She doesn't remember what she initially told police, but she knows that she did not tell them what she saw out of fear of what Furrow and Debbie might do to her. By the time she offered this sworn affidavit, she indicated she was still scared to death of Lee Furrow, but it was her understanding that he now resided in Pennsylvania and Debbie Glasgow was no longer alive. So circling back to the coveralls Diana Roper found, she said on June 9th that was the day she picked up the coveralls Furrow had left on the floor of her closet. She looked at them. She saw the blood splatter and actually called her dad, who in turn called the San Bernardino Sheriff's Department. According to the deputy who was dispatched to Diana's house, the coveralls were heavily splattered with blood. The deputy took the coveralls into evidence and gave a report to his supervisor. That report, which was dated June 10, 1983, stated that Diana Roper suspected that the bloody coveralls were from the Chino Hills murders and has further information regarding that incident and or possible suspect or suspects. The deputy who picked up the coveralls and booked them into evidence subsequently discarded the coveralls into a dumpster during Kevin Cooper's preliminary hearing involving his capital murder case. That deputy later stated at trial that he acted alone in the destruction of the bloody coveralls. However, this was determined to be a lie. The initials KS on the disposition report for the coveralls indicated that a senior sheriff deputy named Ken Schecknengast approved the destruction of the coveralls. And furthermore, the state did not provide the disposition report to Kevin Cooper's attorneys until long after the trial. There is no evidence that anyone in the San Bernardino County Sheriff's Department ever performed tests on the blood on the coveralls. The deputy who had received the coveralls from Diana Roper had some previous interactions with her sister, and her father, and because he had known them previously, though the nature of those interactions is not known, but it was because of this that the deputy took the issue with the coveralls and what Diana had told him seriously. In an audio-taped interview with Kevin Cooper's investigator, this deputy stated, quote, "With my relationship with Carrie Kellison and Diana Roper and her family, I know their involvement in the crime, and as far as committing murders, as well as giving up murderers. They've given very good information on a murder before. I'm not exactly sure what murder he's referring to. I have an idea, and towards the end of this, I'm going to talk about that. Diana Roper and Lee Furrow separated immediately after the murders, and Diana began living with a man named Kenneth Kuhn. In November of 1984, Kuhn became incarcerated at the California Medical Facility in Vacaville. According to another inmate at Vacaville named Anthony Wisely, Kuhn confided some information in him while they were in lockdown smoking marijuana together. Wisely was interviewed on December 19, 1984, by a San Bernardino County Sheriff's deputy. That deputy stated in his report that Wisely was in prison for a period of 2 years under the Psychotic and Remission Program, and part of what Wisely told him directly recounted the Ryan Hughes murders. And his story also closely matches Diana Roper's story. Wisely said that Kuhn told him that he was with 2 other guys and they were all part of some Aryan Brotherhood group, and that they had driven to the Chino area to collect a debt. That they drove to a residence in Chino, and that the 2 guys got out and they were inside for about 10 or 15 minutes, and one of them was carrying 2 axes or hatchets. They also had gloves on, and that one of them had made the statement that the debt was officially collected. Then the first guy came out, turned around and said, "Who was that?" And then again said, "Who the F is that N-word?" He said that the one who made that statement was looking in the direction of the window, and he saw a black subject through the window, and that the one subject told him to get out of there. He said that Kuhn was dropped off in San Bernardino somewhere, he does not know where, and that he stated that he went to his old lady's house and changed his coveralls, and that Kuhn also told him that the statement that one of the guys that came out of the Ryan house was upset because they had apparently left one of the kids alive. Kuhn told Wisely that these persons apparently collected the debt at the Ryan's house, and that they were debt collectors for the Aryan Brotherhood group, and that they had been to the pen for murder before. And it also includes or involves someone that is currently on death row. And again, I will circle back to who this supposed debt collection involved. That was that person that was on death row that they're referring to. It is an incredibly important detail in terms of Lee Furrow and his involvement and motivation, potentially, in the Ryan Hughes murders. So Wisely didn't know anything about the black person seen in a window there in Chino. He didn't have any more detail about that. And Wisely also told the deputy that he knew Kuhn's old lady to be named Diana Roper. Following his interview with Wisely, the deputy went in and interviewed Kuhn, and Kuhn confirmed what Wisely had said about the coveralls, except Wisely had stated that it was Kuhn who had changed out of the coveralls, but it wasn't. It was Lee Furrow who ran into the house to change. The deputy asked Kuhn if he knew that Diana Roper had turned the coveralls over to authorities, and he said that he did, and to the best of his recollection, it was his understanding that Diana found some bloody coveralls that belonged to Lee Furrow, and this happened directly after the discovery of the murders of the Ryans and Christopher Hughes. Kuhn said that he knew that the cops apparently destroyed them or lost them, and nothing more was ever heard about them. And in this interview, Kuhn gave an alibi for the night of the killings. He said that he did not go to the music festival with Lee Furrow and Diana Roper. He said that he was aware of the festival that weekend, but he was in the Gorman, California area and came back to the San Bernardino area shortly afterwards. Kuhn also said that he was not affiliated with the Aryan Brotherhood group that the others had belonged to, and he refused to talk about that subject any further. Now, here is the problem with this information coming from the people associated with Lee Furrow. They had been interviewed on December 19th, 1984, but the state and the prosecution's office did not provide the information ascertained from these interviews with Wisely and Kuhn until the morning of January 2nd, 1985. And that was the day Kevin Cooper was scheduled to take the stand and testify on his own behalf at his capital murder trial. Kevin's investigator, once he had this information, went to go and interview Wisely himself 10 days later on January 12th, but in speaking to him, his investigator noted that Wisely was very wary and unwilling to speak to the investigator, but eventually provided a little bit of information. Since the time Wisely had made contact with the sheriff's deputy, that was the beginning of troubles that he began experiencing in jail, and ever since he was interviewed, he had been in the hole, which is solitary confinement. Wisely said he did not do anything or commit any kind of violation that should have warranted that, and he was in the hole without cause. He believed that the state was concerned about him and what he knew. And he said to Kevin's investigator that he knew Kevin Cooper did not commit the crime. That if you had to have been there to listen to what Kenneth Kuhn had to say, you would know who did do it. In 2004, the district court was preparing to test the mitochondrial DNA from the hairs found in 10-year-old Jessica's hand. When Lee Furrow was made aware of this, the California Deputy Attorney General relayed to the court that Furrow had retained an attorney, and through his attorney, he refused to provide a hair sample. The Deputy Attorney General did tell the court that Kenneth Kuhn indicated that he would be willing to provide whatever the court requested voluntarily. As it was Kuhn's story, as he confided in Anthony Wisely during their time in jail, that he stayed in the car while the other two men went inside with their axes. If his story is true, then he has nothing to worry about in terms of providing a hair sample. So in his report, Judge Fletcher next discussed witnesses who came forward sometime after the fact involving having seen three men come into a bar the night of the murders. On the evening of June 4th, 1983, three men went into the Canyon Corral Bar, which is located in close proximity to the Ryan residence. A number of employees testified at Kevin Cooper's trial that the men entered into the bar sometime between 8 and 9 p.m. They left and then came back later. The witnesses' estimates of the time that the three men came back varied between 11 p.m. and 1 a.m. And according to at least one of the witnesses, one of the three men was extremely drunk. The bar's bouncer, a man named Ralph Land, though he did not testify at Kevin Cooper's trial, he did state in a tape-recorded interview with Kevin's investigator in January of 1984 that two of the men had really close-cut haircuts and that the other had long, straggly hair, kind of dirty, kind of disheveled, and he thought maybe that they were a couple of Marines who ran into an old buddy or something like that. In 2004, two women provided testimony for the district court. Their names were Christine Slonacker and Mary Wolfe. They were in the bar on the evening of June 4th, 1983 as well, and they said that they were being harassed by two or three men. Christine and Mary had not previously provided testimony in Kevin's case, but they did recall the evening in some detail. They said that they were at the bar with a third friend, and that third friend had been receiving unwanted attention from some men because she was wearing a low-cut blouse. Christine, by trade, is a phlebotomist, and she noticed that the man who was the most aggressive of all three of them had blood all over him. She said that from a distance, it just looked like he was dirty, but as he got closer, it was clearly blood. Now, Christine, she only noticed two men, while Mary noticed three, but she did say that the third man was pretty quiet and standoffish. She also noticed that they were wearing tennis shoes. Mary stated that the man who was not wearing coveralls had medium brown or dirty blonde hair that was longer than the average tucked behind his ears. She also noticed that the man in the tan shirt had spots of blood on his shirt and a small bit of blood on his face. Mary recalled that one of the men was wearing coveralls partly zipped down. The louder man in the coveralls also had blood on him. Christine noted that the men were saying really weird and gibberishy kind of things. When Christine told the man that he was covered in blood, he acted surprised and his behavior suddenly changed. Both Christine and Mary then recalled that the men were soon asked to leave the bar. Another witness who was a regular at the bar named Lance Stark also provided testimony for the first time in 2004. He described what he saw as a couple of young loudmouths being rude to some women at the bar. He also noted a third man with the group that was quiet and not that noticeable. Lance said that the men were scruffy or dirty looking and that one of the men looked like he had grease or mud on him. And he also recalled that one of the women was telling the man that he had something on him too. Lance said that he was visited by somebody he believed was associated with law enforcement. This man pulled up in front of his trailer driving a white Crown Victoria, which is a vehicle commonly used by law enforcement, and this man asked him if he was Lance Stark and proceeded to tell him that it would be in his best interest to not talk about the Kevin Cooper case. And then he drove off. Lance said the Crown Victoria was distinctive because it had a computer sticking out from the dashboard. This visit occurred very soon after one of Kevin Cooper's investigators paid him a visit. When Kevin's attorney met with Lance after this encounter with the man in the white Crown Victoria, Lance told him that he wasn't sure if he should talk to him because he was told not to. And when Kevin Cooper attempted to have what may have been witness intimidation investigated, his attempts were denied by the district court. So at Kevin's trial, we've gone over some of the evidence presented against him by the state, and Judge Fletcher's report outlines those things as being undisputed. Kevin Cooper had walked away from the minimum security wing of the prison in Chino on June 2nd. He spent 2 days in hiding at the Lee Slang house located approximately 125 yards or 115 meters away from the Ryan house, and phone records show that Kevin's last call from the hideout house ended at 8:30 p.m. on June 4th, the night of the murders. In addition to these facts, some of the important evidence presented at trial against Kevin was the eyewitness testimony of Josh Ryan. The spot of blood on the hallway wall of the Ryan house that was consistent with Kevin's blood type profile, a bloody shoe print made by a pro-ked shoe on a sheet in the master bedroom of the Ryan house, a matching shoe print on a spa cover outside the Ryan house, and another in the game room of the Lee Slang house. Then there are the Roll Right prison-issued cigarettes and tobacco found in the Lee Slang house and in the Ryan's abandoned station wagon, the missing hatchet from the Lee Slang house, a hatchet sheath found on the floor of the bedroom of the Lee Slang house, a button found in the Lee Slang house that matched a prison-issued jacket, an empty beer can in the field between the Ryan house and the Lee Slang house, burrs on Jessica Ryan's pajamas, positive luminol tests in a shower inside the Lee Slang house. All of this is evidence that was presented in the case against Kevin Cooper. Now we are going to discuss Judge Fletcher's findings on each one of these pieces of evidence in turn. At Kevin Cooper's trial, the jury heard 2 recorded statements by Josh Ryan, who, at the age of 8, survived the attack in his family's home the evening of June 4th, 1983. The jury listened to the 2 recorded statements made by Josh. In one of them he stated, and in the other he suggested, that he only saw one man on the night of the attack. However, when Josh first arrived at the hospital, he was able to communicate to a clinical social worker that the assailants were 3 or 4 young white males. Deputies misrepresented his recollections, and gradually over time, worked to shape his testimony so that it was consistent with the prosecution's theory that there was only one killer. And Dreamers, I did read in one report that investigators visited with Joshua as many as 24 times prior to Kevin's trial. As for the spot of blood in the hallway, officially known as A-41, it was a single drop of blood in the hallway outside the Ryan master bedroom, several feet away from any of the victims. The spot of blood had characteristics consistent with Kevin Cooper's genetic profile and inconsistent with the victims. The crime lab conducted serological testing of this blood drop and entered it into evidence as A-41 under suspicious circumstances. The criminologist who conducted the testing arrived at one result and then altered his records to show a different result that conformed to Kevin Cooper's known blood characteristics. This same drop of blood has had a history of being quote-unquote consumed during testing and then inexplicably reappearing in a different form for further testing when such testing would prove useful to the prosecution. Let's address the pro-ked shoes now. Within the first few days after the murders, investigators discovered 2 distinctive matching shoe prints tying the crime scene to the Lise Lang hideout house. Later, a deputy in the crime lab discovered a bloody shoe print on a bedsheet that had been collected from the Ryan master bedroom. At trial, the prosecution presented evidence that the shoe that likely made those shoe prints, a pro-ked tennis shoe, was not something available anywhere for retail sale and was only available through institutions such as the California Institute for Men, where Kevin had been incarcerated. The prosecution also presented evidence that Kevin had been issued a pair of those shoes at the prison. The shoe print on the sheet in the master bedroom of the Ryan house, on the spa cover outside the Ryan house, and in the Lise Lang house were discovered after a suspicious delay. The shoe print on the sheet was not discovered at the Ryan house, but rather in the San Bernardino County Sheriff's Crime Lab. A deputy sheriff testified at trial that he discovered the shoe print after refolding the sheet in the lab to match the way it was supposedly folded or crumpled on the floor of the bedroom. Deputy William Bayard was the manager of the lab where the sheet was kept when the shoe print was discovered. Bayard provided critical testimony at trial connecting the shoe print on the sheet to the shoe print in the Lise Lang house. He also testified that the shoe prints were made by a pro-ked tennis shoe. He testified that he already had a pro-ked tennis shoe in his lab, which he matched to the print on the sheet. Pro-ked tennis shoes were manufactured and distributed by the Stride Rite Company. Now get this, dreamers. Deputy Bayard admitted at trial that he might have told the Stride Rite official who testified at the trial that the San Bernardino County Sheriff's Department wanted information from him so they could, quote, shut down certain defenses, unquote. Shortly after Kevin Cooper's trial, Deputy Bayard was caught stealing heroin from the evidence locker at the crime lab. He stole the heroin for both his personal use and to sell to drug dealers. And 2 more facts discovered after trial rendered the shoe print evidence particularly dubious. First, pro-ked tennis shoes, contrary to the testimony at trial, are in fact available at retail stores in the United States. And second, an inmate who testified at the trial that he had issued pro-ked tennis shoes to Kevin Cooper shortly before his escape recanted his trial testimony in a sworn declaration supporting Kevin's application to file his second habeas application. Next, let's address the cigarettes and the tobacco evidence. Kevin Cooper admitted at trial that he smoked the Roll-Right prison-issued tobacco while he was in hiding in the Lise Lang house. Tobacco consistent with the Roll-Right cigarettes was found on the floor between the front passenger seat and the front passenger door of the Ryan station wagon. 2 cigarette butts were also found in the station wagon, and blood type tests could not exclude Kevin as the donor of the saliva on the butts. One of the butts contained tobacco that was consistent with the characteristics of the Roll-Right brand, and it should be noted that the cigarette butts did not appear in the station wagon until a second search of the vehicle several weeks later. The station wagon was discovered in a parking lot in Long Beach, 45 miles or 72 kilometers west of the Ryan house on June 11, 1983. When the station wagon was discovered, dust prints indicated that someone had recently closed the hood. Kevin arrived in Tijuana, Mexico, 125 miles or 201 kilometers south of the Ryan house, and he checked into his hotel at 4:30 p.m. on June 5th, the day after the murders, and stayed at that hotel continuously until June 8th. Then Kevin went to Ensenada, Mexico, where he found work on a private boat. He worked on that boat from June 8th until the day of his arrest, 7 weeks later. The station wagon was processed by investigators under suspicious circumstances. Some cigarette butts from the Lee Slang house were never processed into evidence. Some of those cigarette butts could have easily been planted in the car. What's more, after initial forensic testing, paper from a hand-rolled cigarette butt supposedly found in the station wagon was described as consumed. That same paper reappeared and was offered into evidence. When the paper reappeared, it was significantly larger than the paper in the cigarette butt that had been tested. The paper was initially measured to be 4 millimeters in length. When it reappeared, it was 7 millimeters in length. This is highly suggestive of more tampering and planting of evidence in Kevin Cooper's case. Next, let's address the missing hatchet and the hatchet sheath. On the days that the bodies were discovered, detectives recovered a bloody hatchet on the roadside not far from the Ryan house. The person or persons who had previously used the Lee Slang house testified that a similar hatchet was now missing from the house. Investigators found a sheath for the hatchet in the Lee Slang house near the closet in the bedroom previously used by Kathleen Bilbia, and this is where Kevin Cooper slept on June 3rd. Fingerprint evidence strongly suggests that the hatchet sheath was planted in the bedroom soon after the hatchet was discovered. Furthermore, the owners of the hatchet provided inconsistent testimony about the location of the hatchet before it disappeared. Next, let's talk about the camp jacket button. Sheriff's deputies discovered a green, blood-stained button near the closet in Kathleen's bedroom in the Lee Slang house. It appeared to be similar to buttons found on certain what are known as camp jackets issued at the California Institute for Men. The blood on the button was type A, consistent with Kevin Cooper and Doug Ryan. The green button was discovered under the same suspicious circumstances as the hatchet sheath, strongly suggesting that it was planted in the bedroom after Kevin Cooper had become a suspect. Furthermore, its color showed that it came from a green prison-issued jacket. Undisputed evidence at trial clearly showed that Kevin was wearing a brown or tan prison-issued jacket when he escaped. Next, we're going to talk about the empty beer can. In the refrigerator in the Ryan house, there was a 6-pack of Olympia Gold beer with 1 can missing. Another can in the refrigerator, as well as the wall of the refrigerator, were smudged with reddish stains. Deputies found a stained, nearly empty can of Olympia Gold in the field between the Ryan house and the Lee Slang house. The stain on the can in the field and on the wall of the refrigerator tested positive for blood. The blood stains on the beer cans were so degraded that the lab could not conduct any further tests, and deputies failed to collect the stain on the wall of the refrigerator as evidence, and no one analyzed the contents of the nearly empty beer can. Next, we're going to discuss 2 burrs found on Jessica Ryan's nightgown. 2 burrs were found stuck inside of Jessica's pajamas, approximately 10 inches up from the bottom hem. The prosecution argued to the jury that because of the top of Jessica's nightgown did not have holes corresponding with some of her post-mortem chest wounds, that at some point an assailant must have raised Jessica's nightgown and in the process of doing so left those burrs. The prosecution also presented evidence that similar burrs were found on the inside of the Ryan station wagon and on a blanket found in the closet where Kevin Cooper slept on June 3rd. Plants producing the burrs grew in the field between the Ryan house and the Lee Slang house. The plant that produces the burrs is common in Chino Hills. It is unusual for such burrs to transfer from one fabric surface to another. Once the burrs have adhered to a surface, typically they must be physically plucked in order to be removed. Furthermore, the coroner found a small beetle in Jessica's body bag. This beetle is nocturnal, suggesting that Jessica may have been outside during or soon before the murders when she could have picked up the burrs. These burrs were used to link Kevin Cooper to the crime scene at trial. Next, we're going to address the positive luminol tests in the shower in the Lee Slang house. Detectives tested the shower and sink in the bathroom adjoining the bedroom Kevin slept in for traces of blood. Luminol testing revealed the possible presence of blood on the shower walls in a broad band approximately 2 feet to 5 feet above the floor of the shower. When Kathleen Bilbia moved out of the house a short time before the murders, she cleaned the bathroom with bleach, and bleach is known to react with luminol the same way blood does. In order to exclude the possibility that a luminol reaction is caused by bleach rather than blood, a 2-stage test is required. The evidence suggests that the detectives only conducted a 1-stage luminol test. Furthermore, the staining pattern in the shower is not consistent with the person cleaning up after being covered in blood. The luminol test did not indicate blood in the bottom portion of the shower, and it did not reveal patterns of drainage either. One would expect that the blood rinsed from a person's body to travel downward in the shower rather than moving horizontally in a broad, uniform 3-foot horizontal band. Therefore, the luminol reaction in the shower is probably attributable to Kathleen's cleaning materials and not the presence of blood. And there was also no indication that any bloody clothing was removed and placed anywhere near or around the shower. And dreamers, I'd also like to add that if the killer had showered off in the bathroom in the Lee Slang home, there would not have been so much blood found in the station wagon because it would have been clean. And somehow Kevin Cooper managed to find a new set of clothes to wear too? No, the killers murdered the Ryans and Christopher Hughes, jumped in the family station wagon covered in blood, and fled the scene. No one showered and deposited blood in Kathleen's bathroom. But at trial, they said Kevin Cooper did. Judge Fletcher followed up with the following discussion, and he cites a whole bunch of court cases, so I'm going to leave out all that stuff and just tell you the breakdown of what he said. He said that Kevin Cooper advances several claims in his current habeas application, and it is his opinion that 2 of his claims are meritorious, in other words, commendable. In part, he means that they appear to be meritorious on the current record. In part, he also means that if the district court had done its job, including the EDTA tests on Kevin's blood on that tan t-shirt as they were directed by the appellate court to do so, the likelihood of their being meritorious would be much higher. First, Kevin Cooper claims that the state presented false evidence at trial, and second, he claims that the state failed to reveal exculpatory evidence. Under both of these claims, Kevin Cooper claims actual innocence. When Kevin Cooper was granted permission to file his second habeas application in 2004, the appellate court specifically directed the district court to test Kevin's blood on the tan t-shirt for the presence of the preservative EDTA. The purpose of the test was to determine whether his blood had been planted on the t-shirt. The importance of this test was clear. Either Kevin Cooper is guilty as sin, or he was framed by police. There is no middle ground. The testing was not meant to determine whether the state presented false evidence at trial. The state did not put the t-shirt into evidence. Rather, Kevin Cooper introduced it into evidence because the state could not show that any of Kevin's blood was on it. Thus, even if individuals acting on behalf of the state did plant Kevin's blood on the t-shirt, they likely did so long after trial, after DNA technology became available, and after Kevin himself requested that the DNA testing be performed on the t-shirt. If the individuals acting on behalf of the state planted Kevin's blood on the t-shirt, this raises a very powerful inference that numerous pieces of evidence presented at trial were also planted on behalf of the state. If this is so, presenting this evidence violated Kevin Cooper's rights to due process and is the basis for a claim of innocence. In regards to the EDTA preservative testing on the t-shirt, in its order, the district court wrote, based on the last-minute representations made by the petitioner regarding scientific testing capabilities, the panel of the Ninth Circuit Court concluded that the district court should order EDTA testing. When discussing the EDTA testing during a hearing, the district court stated that the panel didn't get it. Whether as a result of its hostility to the EDTA testing or for some other reason, the district court failed to comply with the appellate court's decision to perform the testing. The district court incorrectly concluded that EDTA testing failed the test of admissibility into evidence, writing, quote, "The ubiquity of EDTA in the environment prevents any meaningful interpretation of the significance of an elevated level of EDTA within a forensic sample, and therefore EDTA testing is not reliable." The district court's exclusion of EDTA evidence was based on an error of law, thereby constitutes an abuse of direction. The court attempted to confuse or mislead the reliability of EDTA testing when it is uncontested that laboratory testing can reliably determine the amount of EDTA in any given sample. The district court came to the conclusion that even if EDTA testing was admissible as evidence, the results in Kevin Cooper's case would not support his contention that his blood was planted on the t-shirt. And Dreamer's Judge Fletcher disagreed. He found numerous errors made by the district court conducting the EDTA testing and in refusing to continue the testing, and that even with the minimal testing that was conducted, the results strongly suggested that Kevin Cooper's blood was planted on the t-shirt. They made 6 fundamental errors. 1. The district court refused to allow any of Kevin's experts to assist in choosing the portions of the t-shirt to be tested. The court refused to allow Kevin's experts to even see the t-shirt. 2nd, the district court refused to allow any testing of the samples chosen in order to determine whether the stains on the samples were actually blood stains. 3rd, the district court refused to permit discovery into why blood from vial VV-2, which is the blood taken from Kevin 2 days after his arrest, contained the DNA of 2 different people. You heard that right, dreamers. The vial of blood taken from Kevin Cooper contained the DNA from 2 different individuals. What exactly does that say to you? It's pretty obvious, right? Someone removed some of Kevin's blood from the vial and then added someone else's blood to conceal the fact that he or she had removed Kevin's blood. And why would someone want to take Kevin's blood out of the vial? I don't even think I need to tell you the answer to that question. 4th, when the state-designated lab came back with the result of an extremely high level of EDTA in the sample supposed to contain Kevin's blood, thereby indicating that the blood had been planted, the lab director withdrew his results because of an unspecified quote-unquote contamination in his lab. Wait, what? The lab found elevated levels of the EDTA preservative in the samples that contained Kevin's blood, So they decided that their lab was contaminated, so the results of the testing were tossed out? Yeah. And furthermore, the district court refused to permit Kevin's attorney to see the lab's raw data or notes, thereby preventing an inquiry into whether there had been contamination and the significance of such contamination. Also, dreamers, don't forget, the first time around when the t-shirt was tested before DNA, when there was blood typing and profiling, nothing on the shirt matched up to Kevin's profile. And then all of a sudden, when Kevin called for post-conviction DNA testing, his DNA magically appears. Right. And fifth, the district court erroneously concluded that several samples from the t-shirt were proper controls, when in fact they were not. The samples contained both human DNA and EDTA preservatives, and it wasn't supposed to be. It was supposed to be a clean sample of the shirt with nothing on it, which indicated that they likely contained blood that had been planted on the shirt. Because the district court erroneously concluded that these samples were proper controls, it erroneously disregarded the test results obtained by 2 labs. Seriously? The control sample contained DNA and the EDTA preservatives. So when the lab results came back, ostensibly also containing DNA and EDTA, they saw that as what was supposed to be present in the sample rather than an anomaly and disregarded it? Really? Just wow. And finally, sixth, when the district court concluded that the results of the EDTA testing were inconclusive, it refused to permit more testing, even though such testing was very much feasible. So, dreamers, are you mad yet? Well, get ready because it gets even better. Kevin Cooper's expert, Dr. Peter DeForest, repeatedly sought to participate in the process of examining the tan t-shirt and determining which parts of the t-shirt might be suitable for sampling. On August 4th, 2004, Dr. DeForest filed a declaration noting that new cuttings of the t-shirt would be needed to perform the testing. He wrote, "It is essential that the t-shirt be inspected in person to select the areas to be sampled by cutting, as well as to serve as suitable control areas." A month later, on September 4th, Dr. DeForest wrote a letter to the district court stating that he was concerned about the testing protocol that they had been developing, stating, "This protocol was generated without significant input from me. I feel this protocol is flawed. I will not agree to do any sampling according to this protocol. It will not be possible to obtain any meaningful quantitative results using it. Once I have examined the shirt, I am willing to design an approach for review by another scientist or develop one in conjunction with a criminalist representing the prosecution. As I have been trying to explain for some time now, there needs to be a careful assessment of the shirt followed by a scientific consensus on the pre-extraction sampling. The sampling needs to be taken in such a way that it is possible to relate any quantitative findings of EDTA levels to a specific amount of a blood stain. This is not possible with the protocol specified in the order. In addition, there is the possibility that a scientific consensus might be that sampling that would allow a meaningful result is simply not possible. In such a case, samples should not be taken. The response of the district court was to exclude Dr. DeForest. 3 days after the date of Dr. DeForest's letter of September 4th, 2004, the district court ordered that the t-shirt be sent to Dr. Lewis Maddox of the Orchid Cellmark Lab. This lab is not associated with Kevin Cooper or the state. The court directed Dr. Maddox and Gary Sims to prepare what is known as Area 6G of the t-shirt for testing and to select other portions of the t-shirt to use as controls. Gary Sims is the director of the California Department of Justice Lab. The court's order did not allow a representative of Kevin Cooper to be present during this selection process. Dr. DeForest had predicted this would be the case. Area 6G of the shirt, the area specified in the court's order, was the area that had been originally tested for DNA. That earlier testing had confirmed Kevin Cooper's blood was present in Area 6G. Upon close inspection by Dr. Maddox, Area 6G turned out to be unsuitable for further testing because there was no blood remaining in that area. The state notified the district court of this fact on September 13, 2004. That same day, Kevin's attorney wrote to the district court. Most importantly, the petitioner vigorously requests that an expert of his be allowed to inspect the T-shirt and be a part of the selection and preparation process for the EDTA testing. That same day, at 5:30 p.m., the district court denied Kevin Cooper's request to have his own representative present during the selection and preparation process, writing, "The court denies petitioner's request to have his own observer present at the preparation for the T-shirt for EDTA testing. The court acknowledges that the 6G stain is not suitable for testing. The court orders that Dr. Maddox, in its consultation with Mr. Myers, who is the state representative, to select an appropriate stain area and prepare it for EDTA testing." And herein lies the problem. As a matter of due process, a court is required to allow both sides to participate when important decisions are made. Whereas here, serious objections were made to the manner of choosing and processing samples to be tested, the district court failed in its duty to provide a fundamentally fair process. Dr. Maddox and the state representative, Mr. Myers, chose an area of the T-shirt between stains labeled 6J and 6K as a replacement area for Area 6G. In their view, this area was likely to contain Kevin Cooper's blood, and therefore took their samples from this area. They divided the samples into 3 pieces. They sent one to the state-designated lab. They sent one to Kevin's designated lab, and they retained the 3rd piece at Dr. Maddox's lab. But nobody tested the new sample or any part of it to determine if any of the 3 pieces actually contained blood. Kevin Cooper objected to the failure to test the newly chosen sample for blood. He specifically requested that it be tested to determine if it contained blood. The district court denied the request on the grounds that Kevin Cooper had not previously requested testing of the sample for the presence of blood. The district court's refusal to test the newly chosen sample for the presence of blood was wrong on 2 counts. First, the district court was wrong procedurally. It is unfair to fault Kevin for not having previously requested testing of the sample for blood. Up until September 13th, Kevin reasonably assumed that the sample to be chosen for testing would come from the stain in Area 6G, which everyone believed contained Kevin's blood. It was therefore unnecessary to request testing of a sample from Area 6G for the presence of blood. Such testing only became necessary when a new sample was chosen. After Area 6G was deemed unsuitable, even the state told the district court that additional testing of the subject sample would be required to determine whether Kevin's blood is actually present in the stain. Kevin had no reason specifically to request this additional testing after the state said it was required. Second, and more important, the district court was wrong substantively. Because of the failure to test the new sample for the presence of blood, it was possible that, as intended by the protocol, all of the pieces of the new sample sent for EDTA testing had Kevin's blood. But it was also possible that one or more of the pieces had none of his blood. The second possibility was greatly enhanced for the new sample as compared to the old one from Area 6G. The new sample was adjacent to Area 6G, and therefore Dr. Maddox and Mr. Myers assumed that it contained Kevin's blood. But it was unclear how far in the new sample Kevin's blood extended, if indeed his blood extended into the new sample at all. What's more, The new sample was both large and more irregularly shaped than the old sample, making it even more likely that any blood on the sample was not evenly distributed throughout the entire sample. These characteristics of the new sample may well account for the radical difference obtained by the two labs in testing their sample pieces. The state-designated lab found an extremely high level of EDTA in its piece. The Cooper-designated lab found an elevated but lower level of EDTA in its piece. This disparity could well have happened because the state-designated lab tested a piece that contained Kevin's blood, and the Cooper-designated lab tested a piece that did not contain his blood or contained considerably less of it. If the district court had permitted testing of the new sample for blood, specifically Kevin's, we would know the answer. Now let's talk about vial VV-2. As mentioned earlier, vial VV-2, which contained blood taken from Kevin Cooper a few days after he was arrested, but years later, it was discovered to be a mixture of DNA from two different people. So that has us asking this question. Why in the world would the vial of blood drawn from Kevin back on August 1st, 1983, 2 days after he was taken into custody, have the DNA of two different individuals in it? Two criminalists from the San Bernardino County Sheriff's Department drew the blood from Kevin. They put the blood into the vial VV-2, which also contained the EDTA preservative. So, 21 years later, when the court ordered the testing of the hairs Jessica had clutched in her hand, the state made a mistake. Evidently, they sent a card containing blood from vial VV-2 to the doctor in charge of testing the hairs. Now, this is a very important fact, dreamers. This would be the first time since 1983 that any non-state personnel had been permitted to see or test blood from vial VV-2. And the doctor tested the blood from the vial, and when he did so, he did not know that the state didn't mean to send that over. They meant to send the hair. And that is when the doctor discovered that the blood from vial VV-2 contained the DNA of two or more people. And this, Judge Fletcher said in his dissenting report, was a truly startling finding. And it was on August 2nd, 2004, that the doctor told the court of the findings. Vial VV-2 originally contained only Kevin Cooper's blood and should have continued to contain only Kevin Cooper's blood. The most logical explanation for the finding is that someone added another person's blood to the vial. And Judge Fletcher pondered probably what a lot of you listening are pondering as well. Why might someone want to have done that? Well, one explanation is clear. That someone took some of Kevin Cooper's blood out of the vial for some purpose, and in parentheses, Judge Fletcher said, planting it on the tan t-shirt, perhaps, and wanted the vial to appear as full as it previously had been. In order to accomplish that, he or she had to add someone else's blood to the vial and bring it back up to the proper levels. Dreamers, are we understanding the implication here? Remember, back when the blood on the t-shirt was first tested, it was found to have contained blood types consistent with at least two of the victims. None of the blood matched to Kevin Cooper's blood type there in pre-DNA testing days. But then, years later, when testing for DNA was found, suddenly Kevin's DNA appeared on the t-shirt. And don't forget how weird the state was acting about who could handle the t-shirt and the choosing of the areas on the t-shirt to test. I would even go so far as to say that the state was probably afraid that someone was going to notice that that blood is not consistent with having been deposited onto the t-shirt in the course of a violent murder happening. So on August 4th, 2004, when Kevin's lawyer brought up the discovery made by the doctor, the 2 or more DNA profiles found in vial VV-2, the court said, "We never expected that it was going to be Kevin Cooper." But it seemed that the court has misunderstood what Kevin's attorney was talking about. He was talking about the blood in the vial, and they seemed to think that he was talking about the hair in Jessica's hand, which is clearly not Kevin Cooper's hair. His attorney cleared up the confusion and said, "It's not the hairs that were sent that we're talking about. It's the known sample of blood that was sent, and that's been contaminated. And there is a very serious issue about that." Kevin's attorney then motioned for an evidentiary hearing to determine the cause for the appearance of a mixture of DNA in his blood sample submitted to the doctor doing the testing. Kevin's attorney said, "VV-2 is the blood sample collected from Kevin Cooper at the time of his arrest. The blood sample should only have contained his DNA. The doctor's report reveals that a mixture of DNA sources was detected in VV-2. In light of prior evidence presented by Kevin Cooper regarding tampering or contamination of biological evidence in this case, the doctor's findings regarding VV-2 are extremely alarming and mandate further inquiry." On February 3, 2005, the district court denied Kevin Cooper's motion for an evidentiary hearing regarding the 2 DNA profiles found in his blood sample that should have only been his. The district court did not even mention the vial of blood or the DNA in its denial. I'm starting to smell a conspiracy here, dreamers. Seriously, how is this even happening? So, on April 22, 2005, in a final oral argument to the district court, Kevin Cooper's attorney raised the subject of the blood contained in vial VV-2 again. He said, "With regard to VV-2, I want to make this clear. There seems to be a possible misunderstanding. VV-2, which is the sample that the doctor tested and found a mixture in, it is Kevin's blood sample. It is not a hair sample. I wasn't sure if the court was clear on that." The court immediately interrupted Kevin's attorney and said, "It's all consumed." Kevin's attorney agreed that the doctor consumed the sample on the card that was sent over for testing, but said that doesn't necessarily mean that there isn't more in vial VV-2 in San Bernardino or at the Department of Justice that could be tested. The state's attorney responded, "I can represent to the court that vial VV-2 was completely consumed by the doctor. The doctor was shipped the remainder of this particular blood sample and she consumed it, and it is reflected in her report, so we don't have any more of that particular reference sample." Of this statement, Judge Fletcher wrote, "The state's attorney seems to have meant to say, or at least to have meant the court to understand, that there was no blood remaining in vial VV-2. If that is what counsel meant to say, it was a startling statement. The state had never before even suggested such a thing. For example, when Kevin Cooper motioned in September of 2004 for an evidentiary hearing on how the DNA of 2 people came to be in vial VV-2, the state did not say or even suggest that the vial was empty. Nor had the state ever presented evidence to support such a statement. Nor had the district court relied on the fact that vial VV-2 was empty in denying Kevin Cooper's motion for an evidentiary hearing. Kevin's attorney told the district court that the doctor's finding that the DNA of 2 or more people was in the blood that came from vial VV-2 was extremely alarming and mandated further inquiry. The district court refused to allow any investigation into the issue, even though the presence of additional DNA in vial VV-2 clearly pointed to evidence tampering by the state. So, dreamers, to be clear, the state messed up and sent blood to be tested for DNA when it meant to send hair. And when that DNA was not supposed to be tested, was tested, turned up 2 DNA profiles when it absolutely should have only been one, Kevin's. So when they were called out on this and Kevin's attorney wanted further testing done to see what the hell was going on with this blood, he was denied. And then later they were told, oh, well, the blood in the vial, that was all used up by the doctor. And I'm sorry, but that's a load of crap. They got caught tampering with evidence and then destroyed it in order to avoid detection. Next, Judge Fletcher addressed the issue with the testing of the areas on the tan t-shirt and the refusal to allow access to the state-designated lab's raw data and the notes concerning asserted contamination. Dr. Maddox of the Orchid Cellmark Lab sent a total of 10 samples to each of the 2 designated testing labs. Dr. Suzdak was the tester designated by the state. Dr. Ballard was a tester designated by Kevin Cooper. Sample 1 was a piece of the t-shirt that had been chosen by Dr. Maddox and Mr. Myers as likely to contain Kevin's blood. Samples 2 through 6 were taken from other parts of the t-shirt and were intended to serve as controls. Samples 7 through 10 were not taken from the t-shirt, and they were also intended to serve as controls. The EDTA preservative results obtained by both doctors are remarkably consistent for all the samples except sample 1 and sample 8. The state's doctor found his piece of sample 1, the sample supposedly containing Kevin's blood, contained an extremely high level of EDTA, more than twice as high as any other sample. If his piece of sample 1 contained Kevin's blood, and if his EDTA result is valid, this indicates that Kevin Cooper's blood was planted on the t-shirt. By contrast, Kevin's designated doctor found that his piece of sample 1 contained somewhat elevated but fairly low levels of EDTA. The state's doctor submitted his report containing the high EDTA reading for sample 1 to the district court on October 5, 2004. But then, 22 days later, on October 27th, without prior warning, the state's doctor withdrew his report. He wrote the following statement about it to the court. On Monday, October 5th, I submitted a report on the Cooper samples tested for the presence of EDTA. I now believe that the samples tested were contaminated with EDTA in my laboratory and therefore must retract the report submitted. I deeply apologize for the inconvenience and confusion that this report may have caused. Kevin Cooper motioned to be allowed access to the state's doctor's raw data and bench notes relevant to his testing of all the samples, and the district court denied Kevin's access to this. Kevin Cooper has never been permitted to see the state's doctor's raw data and bench notes and has never been permitted to investigate the nature and possible significance of the purported contamination. Furthermore, the state's doctor has never been asked to provide an explanation for his conclusion that there was contamination in his lab. So, dreamers, are we picking up what Judge Fletcher's putting down here? When the state's lab came back with results unbecoming of their case, i.e., elevated levels of EDTA preservatives found in Kevin's blood on the tan t-shirt, as it is a strong indicator that Kevin's blood was planted on the shirt using blood taken from vial VV-2, which would also contain the preservative, the doctor came back 3 weeks later and was like, oh, my bad, my lab is a cesspool of contamination, so those tests are no good. Shady, right? So next, Judge Fletcher discussed the district's courts relying on faulty controls in regarding the testing of the t-shirt. So supposedly, 5 of those control samples were taken from the tan t-shirt. When the 2 labs, one for the state and one for Kevin, tested those samples, everybody assumed that they would contain nothing that came from a human being, right? Which is what the control is supposed to be, just the material from the shirt. And this in turn would mean that the controls would have no DNA on them, and that they would contain a minimal background level of EDTA, which can sometimes turn up in background testing of evidence such as this. But when the test results came back, as many as 3 out of the 5 samples supposedly taken from the t-shirt actually contained human DNA. The amount of the DNA in these samples corresponds closely with an elevated level of EDTA in these samples. The combined presence of DNA and elevated levels of EDTA strongly suggests that these samples contained preserved blood that had been planted on the t-shirt. Therefore, these quote-unquote control samples from the t-shirt were not, in fact, controls at all. Yet even in the face of that, the district court assumed that these samples were valid controls. Because the district court assumed that these samples were valid, it concluded that the DNA tests were invalid. And the result of this is that it directly refutes Kevin Cooper's claim that the evidence was planted or tampered with. The court said, from the test data, the court concludes that the levels of EDTA in the subject stain is 110 nanograms. Comparing the EDTA level of the subject stain to that of the control specimen, the court concludes that there is no reliable evidence of tampering. Essentially, dreamers, what the implication here is two tainted pieces of evidence were compared, and because they were found to contain elevated levels of EDTA on both, this meant that no tampering took place. The control sample had DNA on it when it should not have. They tested two pieces of the same material. One was supposed to have been a control, and one was supposed to have come from a blood stain, and it wasn't so, and so it didn't prove a damn thing. Judge Fletcher said, because the district court erred in assuming that these samples were valid controls, it erred in concluding that the results of the DNA tests were invalid. The only sample that could provide a baseline of EDTA in the t-shirt that could serve as a valid control is sample number 6. It is the only sample from the t-shirt that contained no human DNA. Both labs found only background levels of EDTA in sample 6, and those levels were far lower than every other sample taken from the shirt. Remember, the district court found that the levels of EDTA in the shirt were measured accurately by Kevin's designated lab. So the virtual absence of EDTA in sample 6 when compared to the elevated levels in sample 1, particularly the portion of sample 1 tested by the state's designated lab, strongly suggested that Kevin Cooper's blood was in fact planted on the t-shirt. Next, Judge Fletcher addressed the district court's refusal to allow for further testing after both the state's doctor and Kevin's doctor made their reports, and after the state's doctor withdrew his report on the grounds of contamination. If the piece of sample 1 tested by the state's doctor contained Kevin's blood, as previously tested by Dr. Maddox and Mr. Myers thought it did, there is no question that Kevin Cooper's blood was planted on the t-shirt. The district court refused to allow further testing despite the fact that both labs, for the state and for Kevin, still had sufficient amounts of the samples provided to them for further testing. In light of the high levels of EDTA detected by the state's lab on their piece of sample 1, and in light of the unexplored nature of the state's doctor's belief that there was contamination in their lab, it was unreasonable to not pursue further testing. Now hang on, dreamers. I know this is getting really tedious, but it is so important to see and know and understand what the state of California did in this case. And if you think this is bad already, it's going to get worse. But I'm going to end this right now so I can get it ready for you to go live. In part 3, we are going to continue to examine dissenting Judge William Fletcher's report on all the things wrong with the case against Kevin Cooper. And hopefully in part 3, we will get to where his case stands today. So stay tuned. Part 3 is right around the corner. And until next time, sweet dreams.